Hello and welcome to Quimbee CLE. My name is Jillian Cool and I'm a program attorney here at Quimbee. And today I have the pleasure of welcoming attorney Tom Major to discuss how COVID-19 has reshaped the New Jersey landlord-tenant practice. Thomas is currently a principal at Offutt Kerman, where his practice focuses on real estate law and landlord representation, counseling clients in both the multifamily and investment property industry. He has extensive experience in all phases of litigation, including at the appellate level, and Thomas is regularly an invited speaker and faculty on real estate and landlord-tenant subjects, and we are just so thrilled to have him here with us today. Welcome, Thomas.
Hi, thank you. It's nice to see you.
So, Thomas, just to get us started, why don't you go ahead and just give us an overview and an introduction to landlord practice in New Jersey?
Well, landlord-tenant practice in New Jersey is a bit of an odd animal. It's kind of at the intersection of regular civil litigation, regulatory compliance. There's some municipal practice to it. And there's literally thousands of cases that are filed every year that it's hard to encounter someone who hasn't run into either a landlord-tenant problem themselves or known someone who has had a landlord-tenant issue. I think in some of the northern counties, there's in excess of 20,000 cases filed a year, and that's just the northern counties of the state. What's interesting about it is there's so many cases that they're designed to be heard quickly in what they call summary proceedings, which are proceedings with no discovery. So you literally just show up and try the case. And what ends up happening is as soon as you get close to the practice area, you learn pretty quickly what it's like to be on your feet and deal with surprise. And it's I enjoy it because it allows you to see so many variation of cases and meet so many different people and so many different issues that you can really stretch your legal skills while also meeting interesting people along the way. And now after COVID, there's been some pretty serious changes to the practice that I'm excited to share.
Great. So I definitely want to dive into everything post-COVID, but can you tell me a little bit before, like what would a typical landlord-tenant case look like before March of 2020?
Well, before March of 2020, it was a mess. It was like it was a chaotic mess that somehow worked actually fairly admirably given the number of cases. So what would happen is you would file a case on paper. Like you'd literally fill it out or on a PDF editor, print it and mail it in. And then or hand deliver it. And you would have to physically print one copy, the original one for the court, and then another copy for each defendant. So you'd have these stacks of cases and each one would be like copied 10 times. And it was this huge like arts and crafts project to put together. And once you filed it, you waited for the court to serve it. And that would take, let's say, a couple of weeks. And then you get a trial date. When you showed up on the trial date, there'd be sometimes hundreds of people, or maybe 100 or so people jammed into a room waiting for the cases to be called. And the court staff would literally just get a big list printed on a dot matrix printer, like literally with the perforations on the sides. They'd get the dot matrix printer list and they'd just start reading the cases. And people would say here, landlord here, tenant here, landlord attorney. And they would go through all the cases, and then the people that didn't show, those cases were dismissed. The cases that were ready, where both parties were there, were good to go. And that's when the fun started. So imagine there's all these ready cases. Let's say there's 50 of them. There's one judge waiting to hear all the cases. But they also have to be mediated so they can reduce the time spent on cases that could otherwise settle. But there's limited space in the courthouse because there's all these people with all these cases. So what would happen is the case would be marked ready. You'd worm your way through the sea of people, find your adversary, if they were represented or not, and then find some corner of the courthouse or courtroom to talk about the case. And then you try to work it out. If there wasn't another adversary, there was court-sponsored mediation where the court staff would be available to walk you through the mediation process. But those people, try as they might, were super loaded with cases because they were ready to go the same day too. And then the case was ready for trial. And it was try it or go home. So if you showed up unprepared for class, you were going to be hurting for certain. because there was no choice. The court's position was the case is scheduled for trial today. You filed it. You try the case. Or if you were a defendant, let's say a tenant or a tenant's lawyer, the court's position was you got the summons. You knew today was the court date. You're the lawyer. You know how to defend the case. So put the case on.